dear students. I welcome you all to today's lecture on working of the administrative tribunals in India. The main aim of this lecture is to acquaint the students with the working of the administrative tribunals. It explains the emergence of the tribunals in India. The shift from the traditional law courts to administrative court is not a natural development but a dire necessity. Evolution in India. The French model was adopted in India and necessary constitutional amendments were made for the creation of the tribunal system in India. Various tribunals were created under different laws even before the constitutional amendments in India. The Swaran Singh Committee suggested in 1976 for the establishment of administrative tribunals to decide cases relating to the service matters and certain other categories of cases. Consequently, by the Constitution 42nd Amendment Act 1976, dealing with tribunals was introduced in the Constitution. It consists of two articles, namely Article 323A and Article 323B. The object of this part was to provide for the creation of two types of tribunals. Article 323A authorized Parliament to enact a law for establishing tribunals to decide service disputes regarding recruitment and conditions of service of employees of the union, state, local and other authority, including any corporation owned and controlled by the government. Whereas Article 323B empowers the appropriate legislature to establish by law tribunals for adjudication of disputes or offences relating to taxation, foreign exchange, labour, land reforms, sale on ceiling or urban property, election, essential goods and incidental matters. In India, these tribunals do not follow any uniform procedure. The tribunals exercise the powers of a civil court relating to examination, discovery, inspection, production of documents, compelling attendance of witnesses and issuing commissions. Their proceedings are considered as judicial proceedings for the purposes of section 193, 195 and 226 of the Indian Penal Code, and they are deemed to be civil courts for the purposes of sections 480 and 482 of the Criminal Procedure Code. However, the rules or procedures of the tribunals should not violate the requirements of fair procedure, and they must conduct themselves with openness, fairness and impartiality. The main purpose of the amendments was to minimize arrears of the high courts and to provide speedy disposal of service cases and certain other matters of the special importance such as tax, foreign exchange, industrial or labor disputes, land reforms, election of legislative bodies, etc. In view of the advantages of tribunals over ordinary court, the Parliament took a significant step by passing Administrative Tribunal Act 1985. The Act provides for the establishment of not only the Central Administrative Tribunal having jurisdiction, power and authority, but also the establishment of administrative tribunals for states in India except for the state of Jammu and Kashmir. In pursuance of the provisions of the Act, it was decided to establish the Central Administrative Tribunal to adjudicate the complaints and grievances relating to recruitment and conditions of services of persons appointed to public services and posts in connection with the affairs of the Union or any other matter or of any local or other authority within the territory of India or under the control of the Government of India or of any corporation or society owned and controlled by the government in pursuance of the Article 323A of the Constitution and for matters connected therewith. The establishment of Central Administrative Tribunal for civil servants has been a novel exercise as no such tribunal exclusively for the civil servants exists anywhere in the world. There shall be a chairman, vice chairman, judicial and administrative members as the central government may deem fit for Central Administrative Tribunal and for the State Administrative Tribunal, the state government respectively. The composition of the Act was challenged in case of S.P. Sampath Kumar versus Union of India, and on the direction of the Supreme Court, the Act was amended by inserting subsections 2, 4 and 6. In the original Act, it was provided that the tribunal shall be constituted by the chairman or a vice chairman and 2 other members. There was no clear mention about the proportion of judicial and non-judicial members constituting a bench. The amendment provided that a bench will include at least 1 judicial member and 1 administrative member. The composition of state administrative tribunal has been left to the concerned state government. In case of joint administrative tribunal for 2 or more states, the matter will be regulated by the mutual agreement of the participating states and as approved by the central government. In the case of Sampath Kumar versus Union of India, an interim direction was issued on 31st October 1985 regarding the composition of the bench, that is, appointment of judicial member of the tribunal to be made in consultation with the Chief Justice of India. However, appointments already made will not be disturbed. Each bench of the tribunal will consist of 1 judicial member and non-judicial member, and in case of difference of opinion between them, the case shall be referred for decision to the chairman of the tribunal. The chairman is authorized by the Act to discharge the functions of judicial administrative member of its own bench or another bench. He can also transfer the vice chairman or any member from one bench to another bench. He is further empowered to authorize the vice chairman or any member to discharge the functions of another bench. Jurisdiction and powers. The Central Administrative Tribunal will exercise all the jurisdiction, power and authority exercisable immediately before that day by all courts except the Supreme Court. It has jurisdiction in all service matters of the employees of the central government, union territories, public undertakings and registered societies owned and controlled by the Government of India. It also provided that the employees of local or other authorities can also be brought within the jurisdiction of the Central Administrative Tribunal established, but notification to that effect is necessary. The Act does not, however, apply to the employees of Jammu and Kashmir, any member of the naval, military or air force or any other armed forces of the Union, officers and servants of the Supreme Court and High Courts, Secretariat staff of the House of People, Council of States and state legislative assemblies and councils. A government servant appointed by Union who is on deputation in state government has to knock the doors of the Central Administrative Tribunal if there is any grievance caused to him by the state government. State Administrative Tribunal. The Administrative Tribunal for a state shall exercise all the jurisdiction, powers and authority exercisable immediately before that day all the courts except the Supreme Court in relation to the service matters of the state government, employees, regarding recruitment and matters concerning recruitment to any civil service of the state or to any civil post under the state. All service matters concerning a person or a member or a civilian appointed to any civil service of state or to any civil post under the state and pertaining to any service of such person in connection with the affairs of the state or of any local or other authority under the control of the state government or of any corporation or society owned and controlled by the state government. Joint Administrative Tribunal. Joint Administrative Tribunal can also be constituted for 2 or more states. A joint administrative tribunal for 2 or more states shall exercise all the jurisdiction, powers and authority exercisable by the administrative tribunals for such states. Powers and functions of the tribunals. The tribunals exercise hosts of powers concerning their areas and determine the disputes of the employees. Administrative tribunals have also been empowered to punish for its contempt. A tribunal shall exercise the same jurisdiction, powers, authority in respect of contempt of itself as a high court. Principle of natural justice should be applied by the tribunals in deciding petitions, and the tribunal should not be bound by the procedure laid down by the Code of Civil Procedure. The tribunal is vested with the same powers as the civil courts under the Code of Civil Procedure 1908. It may summon and enforce the attendance of any witness for examining under oath. It can receive evidence on affidavit. It can examine the witnesses. The tribunal is empowered to review its own decisions and in all procedural matters, including the fixing of places, times of inquiry, and in deciding in public, the tribunals are free to regulate their own procedure. The tribunal, in order to regulate their own procedure, must conform to specific rules framed by the central government and to the principles of natural justice. Exclusion of jurisdiction of courts. In relation to service matters, the jurisdiction, powers, and authority is vested with the administrative tribunal, with the exclusion of various courts. Before establishment of the administrative tribunal for service matters, the civil courts were entertaining a suit for enforcement of any civil right. The jurisdiction of these courts is now barred. There is clearly an express provision for exclusion of the civil courts in civil matter under the provisions of the Act. Initially, there was a provision for the exclusion of all courts except the Supreme Court under Article 136 of the Constitution. This section has been amended after the case of Sampath Kumar, and these words, "no court except the Supreme Court or any industrial tribunal, labor court, or other authority constituted under the Industrial Disputes Act 1947 or any other corresponding law for the time being in force shall have been inserted." The jurisdiction of High Court under Article 226 and 227 has also been barred by this section. It cannot be said that civil servants don't have the right of judicial review through the establishment of administrative tribunal by debarring the jurisdiction of High Court. The change made is that the employees shall first go to the administrative tribunal and thereafter to Supreme Court. However, the decision in L. Chandra Kumar has restored the appellate jurisdiction of the High Court. Transfer of pending cases. The suits or proceedings shall stand transferred on the appointed day, but the appeals pending in the High Court would not be transferred to the tribunal. Initially, there was a provision that all the suits or appeals pending before the High Court or the Supreme Court shall not be transferred to tribunal, but after amendment, there was no question of transfer of pending petitions under Article 32 from the Supreme Court to the Administrative Tribunal. Now, no judicial order is required for such transfer, and it will be enough if the registry or office of the court or the local tribunal obtains an administrative approval for transfer of records to the tribunal from Chief Justice, District Judge, or Chairman of the local tribunal, as the case may be, and the cases will be transferred automatically. Provisions for filing certain appeals. The Administrative Tribunals Act 1986 inserted new section 29A, under which provision has been made for such appeal which had not been expired till the appeal would be entertained by the tribunal within 90 days from the date of receipt of decree or order, or 25th March 1986, whichever is later. Tribunals and the judicial approach. In Sampath Kumar versus Union of India, the constitutionality of the Act was challenged before the Supreme Court on the ground that the exclusion of judicial review of the High Court violated the basic structure of the Constitution. The Constitution bench upheld the validity of the Administrative Tribunal Act 1985. Justice Ranganath Mishra observed that the judicial review by this court is left wholly unaffected, and thus there is a forum where matters of importance and grave injustice can be brought for determination or rectification. Thus, exclusion of the jurisdiction of the High Court does not totally bar judicial review. The court in Minerva Mills versus Union of India did not point out that effective alternative institutional mechanism or arrangements for judicial review cannot be made by Parliament. Thus, it is possible to set up an alternative institution in place of the High Courts for providing judicial review. The whole question of constitutionality of the Act once again came under the scrutiny of the Apex Court in the pace-setting case of L. Chandra Kumar versus Union of India. The court in this case held that Sampath Kumar was decided against the background that before the High Courts had exploded in an unprecedented manner, and therefore alternative institutional mechanism was necessary to remedy the situation. The court further held that because the constitutional safeguards which ensure the independence of the judges of the Supreme Court and the High Courts are not available to the members of the tribunals. Hence, they cannot be considered full and effective substitute for the superior judiciary in discharging the function of the constitutional interpretation. Against this backdrop, the court came to the conclusion that administrative tribunals cannot perform a substitutional role to the High Court, and it can only be supplemental. Therefore, clause 2d of the Article 323A and clause 3d of Article 323B of the Constitution, to the extent they exclude the jurisdiction of the High Courts and the Supreme Court under Articles 226, 227 and 32 of the Constitution, were held unconstitutional, and for the same exclusionary clause in 1985 Act, which contains exclusion of jurisdiction clause, was also declared unconstitutional. However, service tribunals shall continue to be the courts of first instance in service matters, and no writ can be directly filed in the writ courts on matters within the jurisdiction of tribunals. By bringing back the tribunal within the jurisdiction of the High Court, a check on the working of the tribunals was imposed, as well as it will allow only filtered cases to reach High Courts accompanied by reasoned decision on merits, which will be of use in final deciding the matter. In view of this decision, the existing provision of direct appeal to the Supreme Court under Article 136 of the Constitution also stands modified. With this, I conclude today's lecture. Thank you.